Okay, so picture this. It's the spring of 1999. NATO bombs are falling on Yugoslavia as part of the Kosovo conflict. It's a war zone. But at the exact same time, a totally different kind of battle is starting to take shape. Not with bombs and soldiers, but with lawyers and legal briefs inside the grand halls of the International Court of Justice.
Right in the middle of the bombing campaign, the Federal Republic of Yugoslavia does something incredibly bold. It sues 10 NATO countries. And the accusation they leveled, it was explosive. They claimed the bombing was a flagrant violation of international law, an illegal use of force against a sovereign nation.
And here's where it gets really strange, the central mystery we're going to unpack today. You'd think a case this big, about an act of war, would be front and center. But 5 years later, the court came back with a unanimous decision. We can't rule on this. They never even got to the question of whether the bombing was legal. So how on earth does the world's highest court, faced with a literal war, decide it can't even hear the arguments? All right, so the first act of this whole legal drama, it kicks out with a real emergency. Along with their main lawsuit, Yugoslavia asked the court for what are called provisional measures. This was basically them hitting the panic button, pleading with the judges to issue an emergency order to stop the bombing, like right now. Now, the court can't just step in and order countries to stop a war. Before they do anything, they have to be sure they even have the power, the jurisdiction to hear the case in the first place. For an emergency request, they just need to see a prima facie basis for jurisdiction. That's just a fancy Latin way of saying they need to be convinced, on first impression, that there's at least a plausible argument the case belongs in their court. So how did Yugoslavia try to do this? Well, their first attempt hit a brick wall, immediately. They officially accepted the court's jurisdiction on April 25, 1999. The problem? The NATO bombing had started a full month earlier, on March 24th. The court looked at that and said, nope, sorry, the dispute already existed before you agreed to our jurisdiction, so that argument was a non-starter. Their second claim was even heavier. They argued that the bombing campaign was actually an act of genocide, and the Genocide Convention gives the court jurisdiction over those claims. But genocide has a very, very specific legal definition. It requires the intent to destroy a particular national or ethnic group. The court looked at the initial evidence and said, we just don't see that specific intent here. The bombing might be devastating, but it doesn't look like genocide in the legal sense. So the emergency request? Nope, it gets rejected. The bombing continued. But, and this is a big but, the main case wasn't thrown out. The court was very clear that these were just preliminary findings for the emergency order. The bigger question of whether they had final jurisdiction was still on the table, which sets the stage for the final act 5 years later. Okay, so let's jump forward 5 years to 2004. When the court finally delivers its big decision, it pulls a total curveball. It basically ignores those earlier arguments about timing and genocide. Instead, it zeroes in on a much more fundamental and kind of bizarre question. Back in 1999, was Yugoslavia even a country that was allowed to file a lawsuit here at all? This is where things get kind of weird, legally speaking, but it's fascinating. See, after the old Yugoslavia broke apart in the early 90s, the new Federal Republic of Yugoslavia just claimed it was the same country and tried to keep its seat at the UN. But the UN said, not so fast, you have to apply like everyone else. So for 8 years, it was in this crazy legal limbo. It wasn't kicked out, but it wasn't really allowed to participate either. This whole mess was only sorted out in late 2000 when it was finally officially admitted as a brand new UN member. This whole situation was so bizarre, so unprecedented, that the court had to dig up a Latin phrase just to describe it. Sui generis. It literally means in a class of its own. Yugoslavia's status at the UN during that time didn't fit any existing category. It was something else entirely. And this really weird sui generis status, that became the key that ultimately decided everything. The judges basically said, look, to get into our courtroom, you have to come through one of 2 locked doors, and we need to see if Yugoslavia had a key to either one. So, what are these doors? Door number 1 is pretty simple. You have to be a member of the United Nations. If you are, you're automatically in. Door number 2 is for non-members, but it's a much tougher route. You can get in if a specific treaty in force gives you access. The whole case came down to this. Could Yugoslavia get through one of those doors? So did Yugoslavia have the key to that first door? The court said absolutely not. And their logic was kind of clever, in a way. They said the very fact that Yugoslavia was admitted as a new member in 2000 was proof that it wasn't a member in 1999 when it filed the case. That later event clarified the ambiguity of the past. So, door number 1, slammed shut. Okay, so door number 1 is locked. What about door number 2? Could the Genocide Convention pry it open? Well, no. The court made a very strict interpretation here. They ruled that the phrase treaties in force in their own rulebook actually meant treaties that were already in force way back in 1945 when the court was created. The Genocide Convention didn't exist until 1951, so it was too new to be a key. Both doors were locked. Game over. And just when you think it's all wrapped up, here comes the final twist. The judgment was unanimous. Every single judge agreed the court didn't have jurisdiction. But don't let that fool you. Behind the scenes, the court was actually deeply divided on how they got to that conclusion. Yeah, a group of 7 judges, we're talking almost half the court here, including the vice president, were so uneasy with the majority's logic that they wrote a separate opinion. They said, yeah, we agree with the final call, but the road you took to get there, we think it's the wrong one. So you had these 2 camps, right? The majority went down this really complex historical path about UN membership and old treaties. But those 7 judges, they were saying, whoa, hold on. Why are we making this so complicated? We had much simpler, clear reasons to dismiss the case back in 1999. It seems the majority didn't just want to decide this one case. They wanted to make a much bigger statement about who gets to come to court in the first place. So, what's the big lesson here? What should you take away from all this? It's a masterclass in one of the most fundamental truths of international law. Procedure is power. The nitpicky rules about who can sue and when and how, they are every bit as powerful as the laws about war and peace. You can have the best case in the world on paper, but if you can't get through the courthouse doors, it means nothing. But the court was really careful to add one final, super important point. They went out of their way to say that just because they couldn't hear the case, it doesn't mean NATO's actions were legal. They essentially said, our decision today is about procedure, not substance. States are always responsible for their actions under international law, whether a court can rule on it or not. And that's what I want to leave you with. This whole thing raises a huge question. Does this strict, almost obsessive focus on rules make the court stronger by showing it's immune to political pressure and just follows the law? Or does it make it weaker, showing it can get so tangled up in its own rulebook that it's unable to deal with the world's most urgent problems? That's a debate that goes to the very heart of international justice itself.